Next case set for argument this morning is State of Ohio versus Darrin, Donte, Welch. It's case number 29-265. The State of Ohio has waived oral argument on this case as well, so we will just be hearing from Attorney Immel on behalf of Mr. Welch. And we read the briefs and are ready to proceed if you are. You'll have 15 minutes, of course.
Good morning, Your Honor. May it please the court. My name is Chris Immel. I'm here representing Darrin, Donte, Welch in this matter, the appellant. The question before the court here is, did the trial court violate Mr. Welch's right to a speedy trial under 2945.71 when it denied his motion to dismiss? This is a very factual case, and I think that is where we get into this, is in these details and the timeline of as things transpired. Mr. Welch was originally arrested for domestic violence, a felony of the third degree, on September 29th, 2017 for a victim, C.Y., with a date of birth 12/26/2002. He appeared in the municipal court the next day, and by statute, his speedy trial time began to run on September 30th, 2017. As this court is well aware, the state is required to bring Mr. Welch to trial within 270 days of his arrest. Mr. Welch was then indicted on November 7th, 2017 for domestic violence, a felony of the third degree, on a victim, C.Y., with a date of birth 3/8/2004. While this individual has the same initials, it is a completely different person alleged in the indictment with a clear different birth date. While he was arrested for the domestic violence on C.Y. with a date of birth December 26, 2002. Mr. Welch never told his speedy trial time as it relates to the original arrest on C.Y. with a date of birth December 26, 2002. When he appeared in the common pleas court, he entered a not guilty plea at his arraignment on the indictment that was issued November 7th, 2017.
Now it looks like the state is saying there was a request for a continuance on November 15th until, I think they said December 12th, or did he request a continuance at the arraignment?
He may have, as it relates to that indictment with C.Y. date of birth 3/8/2004. I'm submitting to this court that it does not matter whether or not he requested a continuance at that time, because that would toll the time on that indictment with that victim with that date of birth, not on the original arrest.
Thank you.
He had several pre-trials in this matter, and it was ultimately set for trial in February of 2018. The state on the day of trial asked to continue that trial date due to a witness's unavailability. The matter was reset, time charged to the state. It was reset for May 3rd, 2018. On the day of trial that day, the state moved to dismiss the indictment because it miraculously just found the error in the indictment, naming the wrong victim with the wrong date of birth. That transcript of that dismissal has been made a part of the record before this court. The state did not issue a new indictment against Mr. Welch until June 11th, 2018, which was a secret indictment properly naming the victim C.Y. with the date of birth December 26, 2002. If we go back to his date of arrest of September 29, 2017, his 270-day mark would have been June 27th, 2018. So the state does not issue a correct indictment on this matter until June 11th, 2018. An arraignment is set for June 20th, 2018. In the court's order, Mr. Welch did not appear. Mr. Welch was not made aware of this indictment and was not properly served with that indictment for that arraignment. The court, in its order, references a bond that was posted in a municipal court case. And the only bond that was posted in a municipal court case is actually the original arrest as it relates to the victim C.Y. with the date of birth of December 26, 2002. court, in its arraignment order, is aware that Mr. Welch was originally arrested for one victim, as that was the only case that he had posted a bond before. Mr. Welch was then in custody between August 6, 2018 and August 13th, 2018, which for speedy trial calculations would be a total of 21 days. The state and Mr. Welch are in agreement that there are 55 days that pass that count towards speedy trial time between August 13th, 2018 and November 27th, 2018. In our brief, we outlined the days that have passed that count towards speedy trial while also subtracting out the days that are told. From his original arrest of September 29th, 2017, and when his speedy trial time began on September 30th, 2017, until the trial court issued its decision on his motion to dismiss, a total of 364 days passed as it relates to his original arrest for domestic violence on CY with the date of birth December 26th, 2002. In not reversing the trial court's decision, this court would be rewarding the state by allowing the state to file indictments with wrong victims after being arrested, but there's no consequences, where they have prepped the case for trial multiple times, only to dismiss at the last hour, noting that they indicted the wrong victim. I would submit to this court that this case is most analogous to State v. Perry out of the 2nd District, where Mr. Perry was arrested on February 25th, 2011 for aggravated menacing on an Ora Jones and a Kelly Welch. However, he was not charged with aggravated menacing of Kelly Welch until March 21st, 2011. The 2nd District held that because Mr. Perry was arrested for those offenses on February 25th, 2011, the speedy trial time began to run that date, not of the date of March 21st, 2011, when he was then ultimately charged with the aggravated menacing of Kelly Welch. That is exactly, in our position, we believe, is what happened here. He was arrested for domestic violence on a victim, CY, date of birth December 26, 2002. An indictment was not issued on that case until June 11th, 2018. An improper indictment naming a victim, CY, date of birth 3/8/2004, was initially issued. So we would be asking the court to reverse and remand this case to inform the trial court that Mr. Welch's speedy trial rights were violated when the court denied his motion.
What's the effect of the facts being different in the second indictment, and a different victim, as opposed to the original indictment? Does that have an effect on your argument?
I don't believe I understand the question, Your Honor.
Are you alleging that the state knew or should have known that the facts in both indictments were the same, or?
That the state should have known at the time of Mr. Welch's arrest on September 29, 2017, that the alleged victim was CY with a date of birth December 26, 2002. It is clear, based on the Court's Exhibit 1 around the 11:50 mark, that you will hear the officer in the video indicate that Mr. Welch is going down for domestic violence in this case. It is in the reports that the victim is CY 12/26/2002. The state erred in issuing its indictment when it went to the grand jury, getting an indictment for CY with a birth date of March 8, 2004.
With the same set of facts and just the wrong birth date.
Same set of facts. They just named the wrong individual in the indictment. Mr. Welch never told his speedy trial time as it relates to that individual that he was indicted for, or did when that indictment was filed, but he never did for the individual that he was arrested for with the birth date of December 26, 2002. Therefore, the state only had 270 days from September 30th to bring him to trial, which the state failed to do.
And your calculation is 364 days. Does that include the time period between May 3rd, when the court dismissed without prejudice, and the new arrest?
Yes, it does, Your Honor, because he never ever told his speedy trial time, so therefore that time must count.
That's why you're counting that, okay.
That is correct.
Any other questions? Anything else?
No, Your Honor, thank you.
All right, thank you for your argument today. The court will take the matter under advisement and issue a decision. Of course, you will receive a copy of this decision on the day it's released from the courts. And the opinions are also posted on the Supreme Court of Ohio's website, as you also know. Thanks again for being here in our